I'd like to introduce my guest, Stephen Baister, who is formerly Chief Bankruptcy Registrar and currently a Deputy ICC Judge, still providing and dispensing excellent judgments and words of wisdom to those that need him most in their hour of need coming before the courts. My name is Jeff Roberts, and I'm a partner at Collyer Bristow, specialising in insolvency and restructuring. We're here to talk today about the changes to CIGA brought about by recent legislation. And I want to share some views with Stephen, and I hope they'll be interesting and helpful to you all. Stephen, shall we begin by looking back over the period since CIGA came into force?
Yes, that's fine, Jeff. I'm probably going to concentrate on what the future is, but I think it's right, as you suggest, that we look at a bit of context. As we know, we've had a period of restraint in relation to winding up petitions, and that's primarily occupied the court in the form of having to conduct preliminary hearings over whether the coronavirus test applies. And we were very fortunate at an early stage to get some guidance from that. Firstly, from Mr. Justice Morgan, though he actually gave his before the relevant legislation came in. It was one of those cases where he preempted what was going to happen. But then very shortly thereafterwards, in a case from ICC Judge Barber, where she set out very clearly what the court's approach to the coronavirus test was going to be. I only did a couple myself, I would say, and I found it slightly difficult to apply. You had to keep swapping around to think where the burden lay on what part of the test and so on. But by and large, I think it's worked reasonably well. The reason I think there were so few hearings were because I think many practitioners wisely thought, well, let's keep away from winding up at the moment because there are these additional burdens to overcome. And that's why perhaps there's not been a huge volume of case law on it. It may be, I don't know, that you want to chip in with something on your firm's experience as to how it affected you before we go on to look at the present situation. But were you in the camp that stayed away from winding up, or did you soldier on?
We were in the former camp. Rather than add expense to a party already suffering as a result of not having their debts paid, by adding additional costs with the risk that the winding up petition would not go through, we looked at other methods to help them in the short term, and we'll wait and see what happens when the protections end.
I think that was probably a very wise approach, and I think it reflects what my own suspicions have been.
But it was a shame that nothing was similar was done with bankruptcy.
It was astonishing, to be honest. I found it very odd sitting during the coronavirus period to find that on the one hand, there was protection available to, say, a dentist or a group of dentists carrying on business through a limited company, but not to a dentist who was a sole trader or who had incurred a debt as a partner and was fully exposed. And that still seems to me to be odd. And it still, incidentally, seems to be a persistent theme of the changed processes, which I think we're going to go on and discuss, which I might use as my own segue to do so, unless you want to add anything to that first part of our discussion.
No, that's very helpful. I was going to ask you what you think about the new winding up regime.
Well, yes. Let's just remind anyone who's listening of what it's all about, first of all. From the 1st of October of this year, the temporary restrictions imposed by Schedule 10 of the Corporate Insolvency and Governance Act ceased to have effect and were replaced by new restrictions which relax the circumstances in which a winding up petition may be presented, but still do not give creditors anything like a free hand. A winding up petition can now only be presented on the grounds of inability to pay debts if 4 conditions are met. And the first is that it's got to be now a debt for a liquidated demand, it's got to have fallen due, and it's not got to be an excluded debt, which is broadly debt due under a commercial business tenancy. And we'll come on to that a bit later. I know you're going to deal with that.
Yes.
Condition B requires the creditor to seek the company's proposals for payment and warn them of an intention to present a winding up petition if no satisfactory proposal is made in 21 days. C then provides that the creditor may only present a petition once the 28-day warning period has elapsed, and if no satisfactory proposal has been received, and I'll come to that in a moment. And then there's condition D, which is effectively that the petition debt, or the aggregate of them, must now be £10,000 or more. And obviously that's very much a simplification. And I wanted to say something about those new provisions, slightly random thoughts, but the first is that for the first time, winding up law is to some extent being aligned with the law of personal insolvency, it seems to me. First of all, we've got now to have a liquidated debt. Debt's got to be for a liquidated sum before one can petition, and that considerably confines the scope of winding up in the light of the rather broad definition that had been taken in Rule 14.13, which seems to be, for the period in which these new provisions are in force, disapplied. So one of the questions is this going to send the company's court into looking at all those bankruptcy cases on what's a liquidated sum or not?
Indeed, will it be open to a company to say that an offer to secure or compound has been unreasonably refused? I mean, one of the thoughts that occurred to...
Yeah, I'm going to come to that in a moment.
I know you are. One of the thoughts that occurred to me around this sort of thing is it's sort of bringing winding up proceedings in line with the CPR, where letters before claim and the whole protocols around them are designed to see whether litigation can be avoided and a settlement can be agreed. But that's just a sort of left field thought about this. I'm not sure that was intended by the government.
I'm not sure, and I hadn't thought of that, Jeff. And it's a jolly good point, because the second point that aligns the new winding up procedure to a greater extent with bankruptcy is the need now to send this 21-day warning notice, very much like a statutory demand, which is generally the way in which one kicks off a bankruptcy petition. You've only got two gateways to bankruptcy, the statutory demand and the failed execution. But failed execution is very, very little used. So we've now got, in effect, for the first time in winding up, a compulsory 21-day period and notice that's very akin to a statutory demand. I imagine most practitioners will serve two documents or combine them. It's not yet clear how that's to be done, but one has now this 21-day breathing period. Now, before you can present the petition, as I said, you've got to be able to say that the debtor company hasn't made a proposal satisfactory to the creditor. And this is indeed potentially opening up the whole question of the sort of bankruptcy defense that was around and is occasionally used as to whether a petition can be dismissed by reason of an unreasonable offer to secure or compound for the debt. Is all that case law now going to swim into the corporate insolvency field as well, or will it just now be a matter for the discretion of the court, or yet again, will those two things amount to pretty much the same? I don't know. It will be very interesting to see how that develops. We've got, of course, a threshold of £10,000 now for the first time, admittedly more than in bankruptcy, but previously, of course, the 750 or figure applicable that's often regarded as a limit was only applicable in the case of a statutory demand. You could, in theory, wind up a company for a smaller debt if it hadn't paid. And it's always struck me that there's a good case for doing so. The smaller the debt the company can't pay, arguably, the more insolvent it is if it's undisputed. Although equally, you may counter that by saying, well, you're either insolvent or you're not, and the amount doesn't matter. That cuts both ways. But in any event, all those matters, as you rightly point out, align us now much more with the law of bankruptcy. It'll be interesting to see how that develops in the winding up cases in the future. So that was my first point about the new provisions. My second one is about the excluded debt provision. And I'm not going to trespass too much on what I know you're going to talk about, but it does seem to me to represent a potential undermining of the proper class nature of winding up. To exclude a whole class of creditors seems to me to offend against a very fundamental insolvency provision.
I know you have some thoughts about canny landlords and what they might or might not do to get around this legislation.
Yes, well, two things strike me. One was actually your idea that you raised with me in a conversation we had the other day, which is whether landlords will resort to administration more rather than administration. I'm going to leave you to, rather than winding up, and I'm going to leave that to you to develop if you wish to, because it was your thought rather than mine. But the second thing, it seems pretty obvious to me that a canny landlord will be able to take an assignment perhaps from another creditor and get the company wound up using that debt rather than the excluded debt, or perhaps persuading another creditor to do the dirty work for him or her. The other point that occurs to me, and I don't know the answer to that, is if the landlord is able to get some sort of judgment for the rent, and this again will tie up with what you're going to say about arbitration, does that mean, and I think it does, that the underlying claim for commercial rent has merged into the judgment so that the landlord is able to bypass the restriction, because a judgment debt is a judgment debt. The underlying debt that gave rise to it has, of course, disappeared as a result of the doctrine of merger. So there may well be ways that landlords can get around this, but of course, a lot of that depends on this new arbitration process and how that fits into the new scheme of things, which is, I think, the point at which I hand over to you.
Thank you. Well, indeed, and whether landlords seek to circumvent the new arbitration proceedings. Just giving a background to this in terms of the legislation, the Commercial Rent Coronavirus Bill was published on the 9th of November and has already passed its first two readings in the House and is, according to the government website, at 29th November, still in committee stage. So it is going to be a while before it comes in. And it's interesting to see the timescale of that against some of the other restrictions which expire on the 25th of March 2022. The amendments to existing procedures are really around forfeiture of commercial leases, the restriction on landlords for forfeiture for non-payment of any sums due under the lease has now been extended, as I say, to 25th March. The unpaid sums remain due, and only express waiver will waive the right to forfeit when the restricted period ends. The stay of possession proceedings has now expired, but the commercial rent arrears recovery, which was put in place to prevent landlords from using CRA unless an amount of at least 90 days rent, that was the original period, was due. It started at 7 days, increased to 90 days, and the amount has now increased several times and reached 554 days on the 24th of June 2021. This restriction will also apply until 25th of March. We've talked about the statutory demands and presenting of winding up petitions, and now we come to arbitration. The government has proposed a new legislative scheme, previously voluntary, but soon to become mandatory, whereby rents which accrue during periods of forced closure will be ring-fenced. In the absence of a commercial settlement being reached by a landlord and tenant will be capable of being referred to a binding arbitration. The principle is that any such claims for rents will have to be determined by arbitration rather than court proceedings, and that the new legislation will make provision for how arbitrators are to determine such claims. The logic is that the new legislation will ring-fence debt accrued from March 2020, i.e. the start of the pandemic, until sector restrictions were removed. The continuation of restrictions for forfeiture, CRA, and winding up are a continuation of existing legislation. It is the rent arrears arbitration scheme that is novel, and will be interesting to see how that is used, and some indications of how professional arbitrators will approach the ring-fenced arrears while businesses were closed because of lockdowns. It will also be interesting to see whether they have application in large and small cases, or whether in small cases, where not much money is involved, landlords will seek other remedies when restrictions are lifted. And it might, thinking about the logic of what you were saying, Stephen, actually be more applicable in large cases to seek to circumvent the restrictions. We mentioned assignment of other debts, or landlords seeking assignment of other debts to provide a foundation for a winding up petition admin. Indeed, under the new restructuring tool, which is open to creditors, landlords could equally take the bull by the horns and seek a restructuring, which hopefully will benefit them. This is the idea. It's been used in CVAs in the past, where larger landlords, where tenants' business is more aligned than smaller, less well-performing premises, might work together to seek a scheme that benefits them. And we'll come on to that in a second, how the new provisions might help that. Looking very briefly at the amendments to the restructuring tool, a notable feature of the restructuring plan under the Part 26A of the Companies Act is that a restructuring plan can be sanctioned by the court, notwithstanding it is not approved by at least 75% of value of those present and voting, either in person or by proxy of each class of creditors or members, provided the conditions set out in Section 901G of the Companies Act are met. The conditions are interesting, and what we're going to look at this morning is the question of whether the conditions prevent the restructuring tool being used by SMEs, and whether they are only available to larger corporates.
Yes, well, you've always had a problem with the potential costs of this, I think, haven't you? As that's always been a reservation I know you've expressed in the past. How do you think that filters into the whole question of how one rescues the small or medium-sized company?
I am troubled by this, and I think back to when the 86 Act first came in, and administration as a restructuring tool came in. It seemed to be a good procedure and available to all companies, and that was, I think, indeed envisaged by the Cork recommendations. What happened in the event was the Rule 22 report and the increasing complexity around those. And it needn't have been a complicated report, but as oxygen fuels a fire, so court decisions fueled precaution and complexity of future Rule 2.2 reports. And what worries me is the legislation. Perhaps I should just talk about the two conditions in Section 901G that have been brought in. So condition A is that the court is satisfied that if the compromise or arrangement were to be sanctioned, none of the members of the dissenting class would be any worse off than they would be in the event of the relevant alternative. Now, we've seen this before. We've seen this in IVAs and CVAs. There's, it's almost essential that you do have in there for the benefit of the creditors the what ifs. Well, if the debtor goes into an insolvency procedure, what would you get, and what will you get under the proposed scheme? And I'll come back to the relevant alternative in a second. Condition B is that the compromise or arrangement has been approved by a number representing 75% in value of a class of creditors, or, as the case may be, members present and voting either in person or by proxy at the meeting, summoned under Section 91C of the Act, who would receive payment or have a genuine economic interest in the company in the event of the relevant alternative. And here we have that relevant alternative. Now, I think the relevant alternative can go two ways. If judges support a test akin to that applied in a voluntary arrangement, I think we can have a procedure that is fit for purpose for smaller companies. However, the cases that have come before the court so far are all bigger corporations, and they will develop the case law.
I think you're right there. I mean, one of the things that occurs to me, I can't remember the name of the case, but there was a recent judgment of, I think, Mr. Justice Zaccaroli, where all this was dealt with on the basis of what struck me as being pretty sophisticated expert evidence.
The word counterfactual has come into play.
Yeah.
And once we're talking about...
Sorry, I'm just going to say, with VAs, it was normally done as a sort of back of the envelope exercise. There was never a suggestion that one would go into the minutiae of it. It was to give the creditors an idea and to give the court an idea. Sorry, I cut you off slightly there. Forgive me.
Yes, well, once the words counterfactual come into play, and it seems to be the flavor of every piece of litigation I'm involved in that requires a counterfactual to be prepared, well, where do you start? So you then have to look at, probably need accounting evidence as to the back of the envelope test, and then you probably need evidence of an economist, because what you can say, if the company were allowed to have a cross-class cram down and the scheme were to work, then there will be a benefit to creditors as a whole. In order to determine that, you need to run various tests. One is the elasticity of supply and demand for that particular goods or services, and we're back into expensive and complex reports. What is interesting, I think, and I'm referring here to the Hurricane Energy case.
Thank you.
And that's Mr. Justice Zaccaroli. Was that case, in a sense, was living the cork dream, the restructuring dream that companies would realize well in advance of their impending insolvency, that there was going to be a problem ahead, and take steps to rescue the company. In this particular case, the bondholders and the members couldn't agree on the proposed plan, and Mr. Justice Zaccaroli gave judgment. He wasn't satisfied that. Well, he first of all said that he's not there to apply a rubber stamp, and he has to use his discretion. And he then looked at the fairness between the bondholders and the members. In this particular case, the bondholders proposed that they would do a debt equity swap, and they would acquire 95% of the shares, something that the members weren't happy with. But what he went on to say was that even if the parties had agreed, he would not. It wasn't the court's job merely to rubber stamp this. He would then go on to look at whether the court approved the scheme, and he didn't approve the scheme in these circumstances. One of the ideas that came out of his judgment was that, in a sense, insolvency was too far away. And it was very difficult to apply the relevant alternative test because there was too much that could happen in the period. So, in a sense, you're damned if you do and damned if you don't. If you leave it too late, it's too late to rescue the company. If you leave it too long, well, there's not sufficient certainty that the company would go into insolvent liquidation. So, and I suspect it's going to be the bigger cases that test that spectrum from, insolvency the next day versus insolvency a year later.
Which, if I hear you right, Jeff, means you think we're going to get stuck with procedures that, again, are going to become too expensive in the way that administration did, and will shut a wide range of companies out. Is that the logical consequence of what you're positing?
It is. And what I would like to do is I'd like to see some commentary from the courts or some amendments to the legislation to differentiate perhaps a traditional scheme of arrangement, which has been used very successfully as a restructuring tool for larger companies, to provide a dedicated scheme to smaller companies. And maybe the tests would be different in the two cases. I wanted also to look at moratoria, a very underused tool. And I think we have perhaps more suspicious creditors in England and Wales than Americans do, where Chapter 11 has been used very successfully. But the whole concept of debtor in possession has been something that has struggled to get off the ground in the UK. I suppose one of the things that has been an issue, if a party is contemplating a moratorium, is the role of the monitor. And I guess the ambivalence around the role of the monitor has led up professional IPs who would take that role to be suspicious and circumspect about the risks that they would face when there are other procedures around. What I wondered whether you could have a sort of pre-pack restructuring tool where you could prepare the papers for the restructuring and apply for the moratorium shortly before that procedure kicked off, to give the company the necessary protection through the restructuring proceedings.
Well, some would say you might be able to use the CVA or adapt the CVA procedure to achieve that. Otherwise, I'd have to say my initial reaction would be, please, no more insolvency remedies. We've got an awful lot of them around, and by all means, jigger with them. But as you rightly suggest, to simplify, but I think if we have too many, we're going to get ourselves in an awful pickle. Could I just, before we finish this, Jeff, come back to the whole question of costs in the context of this arbitration business again about commercial rent, because arbitration normally costs money, doesn't it? If it's going to be compulsory, one is potentially adding a layer of costs there for landlords, as well as an element of delay. And I wonder again how fair you feel that is, because I imagine you've got the odd landlord on your books at your firm who will have feelings about that. And again, it does seem to be very much part of an effort to keep taxpayers from enjoying the benefit of what they pay their taxes for, namely the ability to go to court and get a final decision there without having to pay for it twice. Any thoughts on that, or am I being a bit wicked there?
Always a bit wicked, Stephen. No, I think that is good. We are talking about a dedicated period in respect to which the restrictions apply. Obviously, in the very largest companies, that might be a large sum of money. But you're right. I suppose the question might be whether the costs of the arbitrator himself, which is the variable, because you don't pay for the judge himself, herself, is less or greater than the court fees involved in a winding up petition or in issuing proceedings, if the canny landlord, for example, buys a commercial debt so that he can bring proceedings or winding up proceedings. I suppose what I'm saying is we are paying for our judges through the court fee. But yes, you're right. I mean, you've got the costs of the arbitrating parties and the cost of the arbitrator to meet and the delay. Lawyers are very clever and love to find a way around a problem. I'm thinking back to the Romalfa case, for example. We find ways around problems, and I suspect there will be lawyers who are finding their way around these restrictions. I suppose it's also a question of how long the arbitration provisions are in play. At the moment, we have various arrangements coming to an end on the 25th of March 2022, which is the period in which the arbitration scheme will be coming into play. A lot will depend, I suppose, on this new variant and whether corona restrictions are going to go on and how long they go on for. But maybe you and I can talk about this when we have our Collyer Bristow CIGA webinar planned for January.
That sounds like a point at which we should wrap this discussion up, Jeff, unless there's anything else. Yeah, I think you're right. We have to see how things move along on the political front, the legal front, and indeed on the disease front. So,
indeed, lots of things in play. Stephen, it is always a pleasure to talk to you.
And you, Jeff. Thanks ever so much.
Thank you so much. Goodbye.